Chapter 3, Legal Issues, Part 6. We mentioned when we were covering warrantless searches in the last presentation, Terry versus Ohio. Well, we actually just talked about the Terry stops. The Terry stops come from Terry versus Ohio, which is a 1968 case. And in this particular case, the real question before the U.S. Supreme Court was, are stops and frisks, so the pat-down searches that we always see in every movie and every television show when police officers stop a suspect, are those legal? Are they constitutional if the officer has less than probable cause? And so what happened was the U.S. Supreme Court said that, and we'll get into the facts of the case in just a second, but the U.S. Supreme Court said the Fourth Amendment does not require probable cause to justify every search, every seizure. Instead, a lesser standard can sometimes be applied, and that lesser standard, according to the U.S. Supreme Court, for stops and frisks is reasonable suspicion. So if you remember, probable cause, the definition of it is it's a reasonable belief that a crime has been committed or is being committed. So probable cause looks to the past and the present. So was a crime committed or is it being committed right now? That's the question for probable cause. Do we have a reasonable belief? Reasonable suspicion asks, is there a reasonable belief that a crime is being committed or will be committed? So it's a little bit different than probable cause in a couple of ways. One, it looks at the present just like probable cause, but it also looks to the future. So here, police are looking at actions that would lead the police that somebody's about to engage in a crime. They haven't done anything criminal yet. Probable cause requires that they've already done something criminal or they are doing something criminal. At least we have a belief that they're doing that. Whereas reasonable suspicion says this is a belief that something is happening right now or is going to happen. And so we want the police to intervene. So reasonable suspicion looks to the present and the future, unlike probable cause, which looks at the present and the past. But also reasonable suspicion is different in that it's a little bit lower standard of proof than we require for probable cause. I can't give you an exact definition because there isn't really an exact definition, a scientific definition that exists. But you'll just have to trust me that it's a lower standard. Reasonable suspicion is lower standard. Why? Because here the police are being proactive. They may be preventing a crime, not responding to it like they usually do with probable cause. So here we don't require quite as much evidence. We do require some evidence to justify their belief, their suspicion, but we don't require quite as high a level as for probable cause because we're only justifying a stop and frisk. So we're not justifying a full-blown search, at least initially. This is a stop and frisk is supposed to last, 10, 15 seconds, a quick pat down of the person. And it's not supposed to be very intrusive. So we're allowing the police to be proactive to deal with these very limited searches on a lesser standard of proof. But it isn't just reasonable suspicion alone that allowed the searches in Terry versus Ohio. There was also a concern for the officer's safety. And so we ask, is this a situation where the officer might have reason to believe that the person could be armed, the person could be dangerous? And so therefore, they can do the pat-down frisk, at least according to the original 1968 case, if, one, they have reasonable suspicion, so it's a reasonable belief that a crime is being committed or will be committed, and they have a concern for their safety. So before they approach this person, they want to pat them down to make sure this person is incapable of harming them right away. So here it might be helpful to talk a little bit about the facts of Terry versus Ohio. In Terry versus Ohio, Cleveland police officers observed Terry and another guy in front of a closed jewelry store. Now, if you actually look at the record, the transcript of the case, the facts are not as clear-cut as the Supreme Court's presented them. But we're not going to worry about that. This is an instance where In the 1960s, the Supreme Court had been ruling pretty much against the police in most cases, and many believed that they were trying to give a victory to the police in this particular case, because the court really cherry-picked the facts and made it look like this was really suspicious behavior. But let's not worry about that for right now. Let's take the facts as the Supreme Court presented them. So the Supreme Court said that Terry was standing in front of this closed jewelry store window at night. He kept looking into it. He kept walking over to his friend who was on the corner and kept talking to him and going back. And the police observed this, and they were experienced police officers. They were veteran police officers. They had seen people casing or checking out locations to rob later, and they had seen that happen before. And as they were watching Terry, they thought, this is what he's doing. He's checking out the jewelry store. He's going to rob it. And so they decided to get out of their patrol car and approach him to see what he was doing. Now, it's completely plausible that he was doing something completely innocent. Maybe he was the owner of the jewelry store, and he was waiting for his wife to arrive and bring the keys that he had forgotten. Or maybe he was, he and his friend were waiting on a ride to pick them up, and instead of waiting on the corner, he decided to go over and look at the jewelry that was in the window because he was going to propose to his girlfriend, or who knows what. So there could have been innocent reasons for why he kept looking in the jewelry store window. But the police wanted to check him out. So when they approached him, they patted him down. They identified themselves as police officers, patted him down, and when they were patting him down, they instantly felt that he had a gun in one of his pockets. So they took the gun out. He didn't have a permit for it. He was arrested for having a gun without a permit. He tried to get that gun evidence suppressed at his trial. He was unsuccessful. He claimed that this was a violation of his Fourth Amendment rights because the police didn't have probable cause to that he had committed a crime. Again, they thought he might be going to commit a crime. They admitted they didn't have evidence that he was committing a crime. And so therefore he didn't have probable cause, then the search wasn't justified. The Supreme Court, as I said, as we began this discussion of Terry, the Supreme Court upheld stops and frisks if they're based on reasonable suspicion, a lesser standard, and if there's concern for the officer's safety. Because the Supreme Court said, we recognize it's dangerous to be a police officer sometimes, so therefore we're going to allow you to do these pat-downs for your safety and because you have reasonable suspicion. The court also said that you had to have, they used another term that I like to use sometimes, articulatable suspicion. So you can either say reasonable or articulable. It's more common to say reasonable suspicion, but what they meant by articulable suspicion, they did tell the police in Terry versus Ohio, look, you just can't pull people out of the crowd and on a hunch just start patting them down. You have to be able to articulate, state, explain reasons why this person looks suspicious. And that's really at the heart of reasonable suspicion. So in this case, they were saying, all of Terry's actions made him suspicious. So it wasn't just that they just randomly pulled people off the street and started patting them down. There was a reason why they stopped him. And so they did the quick pat-down search. If he hadn't had the gun on him, if he had a reason for being there on the streets that wasn't criminal, the stop would have been over in no time. But the court said because they had reasonable suspicion, because they had a concern for their safety, therefore they could conduct this pat-down search, and the search was reasonable under the Fourth Amendment. So we see Terry, these pat-down stops and frisks are now known as Terry stops. We see them all the time. We've had subsequent cases that have interpreted what is the meaning of Terry versus Ohio, and I would argue today that unlike in 1968, the courts aren't as concerned about whether the officer is worried about his or her safety. We pretty much take it for granted that anybody, even a little kid or a 100-year-old grandmother, could be packing some heat, and so therefore the police could pat that person down. So now the real question is, was there reasonable suspicion? Under a case in 2000, a guy ran away from the police as the police were driving by, and the police gave chase, and so at that moment he was seized. And so the question was this justified under Terry, merely running away from the police? And the Supreme Court said, well, running away from the police isn't always grounds for reasonable suspicion, but on the other hand, we can't ignore that sometimes it can be suspicious. So the Supreme Court said that flight, fleeing, running away from the police, can be grounds for reasonable suspicion if the police can testify that it was nervous, evasive behavior. And the Supreme Court said also we look at the location where it occurred. So is this a situation where you just have some kids who are running down the street singing, nursery rhymes and they're running away from the police? Well, that wouldn't be nervous, evasive behavior. Or if you were jogging and you passed the police and so you were jogging away from the police. Is that nervous evasive? No. But if you see the police and you say, holy crap, and you take off running in the other direction, the court said, yeah, that's reasonably suspicious, if it especially occurs in a high crime area. So they didn't say high crime area justified every stop and frisk, but it could justify it in some situations. Of course, this can also open the door to, abuses. That the police could really stretch the definition of nervous evasive behavior, because it's pretty subjective, to justify just about anything. And when we cover racial profiling, we're going to talk about Terry stops and Wardlow and some of these other cases. Pretext stops are another kind of search that we often find, where we take the Fourth Amendment and extend it to give the police even more powers. So in the pretext stop comes really out of a case known as Wren versus the United States, and in this case we have to talk about race because it's a part of the case. And so maybe some of this sounds politically incorrect, but it's part of the case. So Wren was a passenger in a brand new SUV. He was young and black. This was, as I said, a new SUV, and he and his driver were stopped in a high drug area of Washington, D.C. They were stopped at a stop sign for about 30 seconds. An undercover narcotics group of narcotics officers in an unmarked car drove by, saw these two guys sitting at the stop sign. The police officers do a U-turn. They come back and check out. When they go towards the car, they then see Wren's driver make a right-hand turn without putting on a turn signal and driving away at a high speed. Now, I should say he was speeding. It wasn't a high speed. It wasn't like he was doing 110 in a 35 mile per hour zone, but it was a violation of the law. Now, undercover narcotics officers normally don't pull over people for traffic violations. And if you've ever driven through D.C., not too many people get pulled over at all by anybody. But, the undercover narcotics officers aren't going to blow their cover by pulling somebody over. So the belief was they were pulling, but they did eventually pull over Wren, and they didn't even have the equipment to do it. They finally just got Wren trapped in at the next, Wren and the driver at the next stop sign, and jumped out of the car and ran up to the Wren vehicle, and they could see when they looked in the window in plain view that Wren had drugs in his lap. And so they arrested him. And Wren claimed that they didn't have probable cause to make the traffic stop initially, that the court really, at least to view the cocaine, that the court should look at the real motives of the police officers. And the real motives of the police officers were to look at two young black men in a new SUV and think that they're drug dealers. And that is certainly never going to be grounds for probable cause. But Wren was saying that was really what the officers were thinking. So they stopped the car on a minor traffic violation that they would have never stopped them otherwise. And the police officers were saying because they had probable cause to make the stop, they therefore had legal justification to be in plain view of the drugs. Wren said this is making it basically a crime to be driving while black. And so again, I'm throwing political correctness out the window here, but this is what Wren was proposing, and this was a form of racial profiling. The Supreme Court refused to look at the motives of the officers, and they said no. It's much simpler to say, is there probable cause anywhere to make the stop? Could the police officers make a traffic stop, even if they never do as undercover narcotics officers? If they did have that authority still, and in fact they still did, they still were police officers, then that allowed them to pull over Wren, even if it was a pretext. And by pretext, we mean it was just an excuse to get to what they really wanted to do. The right-hand turn signal, the speeding, was just an excuse to pull them over to check them out for drugs. Well, police admit after the Wren case that they can stop almost anyone, anytime, for anything. The traffic laws are their best friend. So these stops can hide